Business Law Corporation Part 2. Business Law Corporation Part 2. Board of Directors, Trustees, and other officers. Based on artificial being, a corporation can only act through its agent. Under the law, all corporate powers shall be exercised, all its business conducted, and all its property controlled and held by the Board of Directors, if stock corporation or trustees. This power of the board may be delegated to its officer or agent and to the executive committee consisting of at least 3 members of the board and appointed by the board. The executive committee enables the corporation to immediately solve corporate problems which cannot otherwise be readily attended to by the board, acting as a collegiate body due to the difficulty of holding special board meetings. However, there are corporate actions which cannot be entrusted to the executive committee, such as the approval of any action which requires stockholders' approval, the filing of vacancies in the board, the amendment or repeal of any resolution of the board which is by its express terms is not so amendable or repealable. It does not mean, however, that the stockholder have no voice at all in management of the corporation. There are specific matters regarding the management of the corporation which requires the approval of at least a majority of or 2/3 of the outstanding capital stocks or 2/3 of the members, such as the removal, increase, or reduction of the directors, 2/3 of the OCS, outstanding capital stocks. The increase or reduction of capital stock and increasing bonded indebtedness, 2/3 of the OCS. The amendments of articles of incorporation, 2/3 of the outstanding capital stock. The amendment, repeal, or adoption of new bylaws, majority vote. Or the delegation of the board of the power to amend, repeal, or adopt bylaws, 2/3 of outstanding capital stocks. Or the revocation of the power given to the board, majority of the outstanding capital stocks. Entering into management contract, majority of the outstanding capital stocks, unless more than 1/3 of the outstanding capital stocks of managing corporation is owned by any stockholders of either corporation, or majority of the members of the board of the managing corporation is also constitutes majority of the board of managed corporation, in which case the vote requires 2/3 of the outstanding capital stocks. The investment of corporate funds in other business, 2/3 of outstanding capital stocks. The sale of all substantially all of the corporate assets, 2/3 of outstanding capital stocks. The authorization of dissolution of the corporation, 2/3 of outstanding capital stocks. The declaration of stock dividends, 2/3 of OCS. In the merger of consolidation, 2/3 of OCS. And issuance of the share in exchange of property needed for corporate purposes or in payment of previously contracted debt, 2/3 of OCS. Number of qualifications of directors or trustees. The minimum number required for directors or trustees is 5, but the maximum number of depends on whether it is a stock or non-stock corporation. For a stock corporation, the maximum number required 15, while for non-stock corporation, the maximum number may be more than 15. Majority of the members of the board must be residents in the Philippines. To be qualified for election as a director or trustee of a corporation, a person must be an owner of at least 1 share of stock or member of a non-stock corporation. Must not have been convicted by final judgment of an offense carrying a penalty of imprisonment exceeding 6 years, or a violation of a corporation code within 5 years prior to his election. In some instances, the law requires that some or all of the directors must be citizens of the Philippines, such as in rural banks, all must be Filipino citizens; private development banks, all must be Filipino citizens; registered investment company, all must be Filipino citizens; bank and banking institutions, 2/3 must be Filipino citizens; financing corporation, 2/3 must be Filipino citizens; domestic air carriers, the chairman of the board and 2/3 of the directors must be Filipino citizens. Liabilities of directors. Like in contract of agency, there is a fiduciary relationship between the corporation and its directors or officers. Directors owe a 3-fold duty to the corporation, to wit, they must be obedient, they must be diligent, and they must be loyal. They must therefore exercise their authority and act not for their own self-interest but for the benefit of the corporation and its stockholders. Hence, they are liable to the corporation and to other persons for breach of trust, negligence, reckless imprudence, and crime. Under the doctrine of corporate opportunity, a director who acquires a business opportunity which should belong to the corporation and thereby obtain profits to the detriment or prejudice of such corporation is guilty of disloyalty and obliged to account to corporation all profits he obtained from such transactions, even though he risked his own funds in the venture. However, this act done by a director may be ratified by the vote of stockholders owning or representing at least two-thirds of the outstanding capital stock. If a board of directors refuses to or neglects to act for a corporation in cause of action against a defendant, a stockholder may file an action in the name or on behalf of the corporation to redress a wrong committed against the corporation. This is called derivative suit. When a wrong committed by a corporation against a group of stockholders, any of them may bring an action in behalf of himself and all other shareholders who are similarly situated. This action is called the representative suit. Individual suit is an action filed by stockholders against the corporation for the redress or wrong which is direct violation of his right as a stockholder. Excuse me. Election of directors or trustees. For the election of directors or trustees, the owners of the majority of outstanding capital stocks or majority of the members entitled to vote must be present. The stockholders or members may vote personally or by proxy. The election may be viva voce. Ibig sabihin yan. But if there is a request from any stockholder member, the election must be by ballot. The election shall be held annually. The term of office of the directors of stock corporation is 1 year or until their successors are elected and qualified. The trustees of non-stock corporation, which may be more than 15, shall be classified at a term of office of 1/3 of their number shall expire every year, and subsequent elections of trustees comprising 1/3 of the board shall be held annually for a term of 3 years. Every stockholder is entitled to cumulative system of voting, which may either be straight voting, when he has the right to vote the number of his shares as to many persons as there are directors to be elected. Cumulative voting by lump sum, where he has the right to vote to a single candidate the number of his share multiplied by the number of directors to be elected. Wow. Cumulative by distribution, where he has the right to distribute the number of his shares to as many candidates to be elected, provided that the total number of his votes cast will not exceed the number of his shares multiplied by the number of directors to be elected. Example: Sixto Hernandez has 1,000 shares entitled to vote. 7 directors will be elected, and the candidates are A, B, C, D, E, F, G, H, I, J, K. He may cast his votes as follows: 1,000 votes each for A, B, C, D, E, F, and G, straight cumulative voting. 7,000 votes for C alone, cumulative voting by lump sum. 1,200 votes for A, 900 votes for C, 200 votes for F, 600 votes for D, 300 votes for E, 700 votes for G, and 1,300 votes for J. Cumulative voting by distribution. Alright. Corporate officers. Immediately after the election, the elected officers must formally organize by electing a president, secretary, treasurer, and such other officer as may be provided in by laws. The president must be a director. The treasurer may or may not be a director, and the secretary may or may not be a director but must be a resident of the Philippines. 2 or more positions may be held concurrently by a director, but not as a president and secretary or president and treasurer as at the same time. The names, nationalities, and residence of the elected directors or trustees and officers should be reported to the Securities and Exchange Commission by secretary or other officers of the corporation. If a director, trustee, or officer will die or in any manner cease to hold office, Such facts should immediately be reported in the Commission. This is to enable the Commission to know who will be the person to contact in the corporation and also to determine whether the corporation has complied with general requirement that at least majority of the members of the board are residents of the Philippines or has complied with the citizenship requirement in special cases. Removal of directors or trustees. A director or trustee of a corporation may be removed by stockholders, with or without just cause, in a meeting called for that purpose. The removal of director or trustees require the vote of stockholders representing at least two-thirds of the outstanding capital stocks or by at least two-thirds of the members entitled to vote. However, the director representing a minority stockholder, one elected by the minority stockholders who united the cumulative voting, cannot be removed without just cause. Right. Filling up of vacancy in the board. Generally, vacancies in a board may be filled up by remaining director, provided that they still constitute a quorum. The following vacancies, however, may only be filled up with stockholders' members. Vacancies caused by the removal of director or directors, vacancies caused by the increase of the number of directors, vacancies caused by expiration of their term, and vacancies where the remaining directors do not constitute a quorum. Meetings. There are four kinds of meeting in the corporation to wit: regular board meeting, special board meeting, regular stockholders meeting, and special stockholders meeting. Provisions common to board meeting and stockholders. Both meetings shall be presided by the president unless otherwise provided in by laws. There must be quorum for both meetings, majority of the outstanding capital stocks or members, and majority of the members of the board unless otherwise provided in the corporation code or in bylaws. Notice in both meetings may be waived by stockholders, members, or members of the board. Distinctions between meeting of board and the stockholders members. Stockholders meetings, regular meetings, are held annually by provided in bylaws or on any date in April. Board meetings, regular meetings, are held monthly as provided in bylaws. Stockholders meetings, generally 2-week notice is required for regular meeting. Board meetings, generally 1-day notice is required for regular meeting. Stockholders meeting, generally 1-week notice is required for special meeting. Board members meeting, generally 1-day notice is required in special meeting. Stockholders meeting shall be held in a city or municipality where the principal office of the corporation is located, and board meeting may be held anywhere or outside the Philippines. In stockholders meetings, stockholders members may attend meetings and vote proxy. Board meetings, members of the board cannot attend meetings by proxy. Stockholders meetings, cumulative voting is allowed. Board meetings, individual voting is required. Irregular stockholders members meeting. All proceedings had and any business transacted at any meeting or stockholders member shall be valid even if the meeting is improperly held, provided that they are within the powers of corporation and all the stockholders or members are present or duly represented at the meeting. Right to vote. The stockholders member may attend meeting and vote personally or by proxy. Share of stock owned jointly by 2 or more persons can be voted with the consent of all co-owners unless they give proxy to one or some of them or any other person. If the share are owned in and or capacity, any one of them can vote said shares or appoint a proxy. The pledger or mortgager of shares of stocks has the right to attend and vote at meetings of stockholders unless he gives that right in writing to the pledgee or mortgagee, which is recorded in the book of corporation. Executors, administrators, receivers, and other legal representatives duly appointed by the court may attend and vote in behalf of the stockholders.